The order to change venue. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine the new order to change venue form. This is scale form PC 608, small letter O. That is the form number. SCAO stands for State Court Administrative Office. PC for Probate Court. The form is 6080. This form was recently revised in December of 2022. It replaces a prior state court administrative office form. The order to change venue is governed by various statutes and court rules as reflected in the yellow arrow in the bottom left, specifically MCR 600.856 and MCR 2.222, 223, 226, and 5.18. These are the court rules and statutes that give rise to the order to change venue. Now you may be asking, what is venue? Venue generally relates to the location of the proceeding, the county. So for example, we have a Wayne County Probate Court, an Oakland County Probate Court, Jackson County Probate Court. Venue typically addresses the location of the court, which is different than jurisdiction. Jurisdiction and venue play hand in hand, but this form and process relates specifically to the changing of venue when a matter occurs within the probate court. Let's kind of work our way through the document. In the top left corner is the court, top right corner is the case or file number, as well as the judge. The top section identifies the court address, the name of the estate. This could be a guardianship, a conservatorship, it could be a deceased estate or a trust. The petitioner's name, meaning who is filing, who had filed the petition for the change of venue, as well as the attorney if there's an attorney. Now this is the order form, not the petition, not the request to make the change, but when the court has entered an order following a request for change of venue. That can originate from a petitioner as well as the court itself. Let's work our way through the form itself. Paragraph 1, it says the case was filed. Pretty simple, put the date there. And service was made, and this is the date that service was effectuated upon a defendant or the interested parties. Section 2 speaks about a judgment if a judgment was entered in the matter, meaning a judgment following a complaint. The order section is really the meat and potatoes of this particular form. It says it is ordered, 1, the venue of the matter is changed to. So this would be an order in which venue is granted for a change, and the new court, probate court, would be reflected there. So for example, it may say Macomb County Probate Court. And then the reasons for the change are little check boxes there. It could be that venue is improper under MCR 2.223, for example. The person may have been domiciled. I'll give you an example here. The person may have been domiciled at the date of death in Macomb County, and the probate estate was commenced in Oakland County. Or the person in a guardianship may be a resident of Jackson County, but when the case was started was a resident of Washtenaw County and then moved and has remained in a new location. The court may change venue. Convenience of the parties is another basis for the witnesses or attorneys under MCR 2.222 subsection large A. The third is an impartial trial cannot be held where the action is pending. And then D, there are other kind of general opportunities to identify an applicable rule that would give rise for the change of venue. So these would be the rulings of the court. Number 2, the filing fees have been waived in those particular set of circumstances. And 3, if there are filing fees required, there's 28 days to do so. And then there are check boxes for the various identifications, whether venue was proper or was improper and then changed, because there are rules that govern the filing fees and expenses relating to whether you initiated in the correct venue or not. Also, there's a kind of a catch-all provision. It says additional information regarding the change of venue can be found here, and there's a click box there. We'll talk about that in a moment, or a hyperlink there. 4, the clerk of the court must prepare the case records transfer. So again, it's going from one court system to another. So for example, from Jackson County to Wayne County. And the Michigan Trial Court records management standards are utilized for that transfer of the file itself from one court system to another. Let's work our way to the back side of the document. Again, a place for the case number, and then there's a provision here that in the event that there was a request for change of venue and it's denied, the court can check box 5 and indicate the basis for the denial of the change of venue, and then there are bases for the court to identify the rationale. And then, of course, there's a spot for the judge to sign and date, and then there's this provision here that talks about a notice of refusal of transfer. It says, I have reviewed this order and it lacks the information necessary for the court to determine under which rule the transfer was ordered. The court refuses to accept the transfer and the case is returned to the transferring court for proper order. So imagine if a judge in Macomb County signs this order and then it is sent to Washtenaw County, the new deputy clerk in Washtenaw County can refuse the transfer because of insufficient bases and information to allow for that transfer to occur, so that the receiving court can make certain that they handle the transfer and change of venue correctly. There's a lot going on here, and with all of these types of probate matters, we strongly encourage you to work with a skilled, competent probate practitioner to know how to navigate through these complicated court rules and statutes that govern and give rise to these types of proceedings. At the Probate Pro, we are passionate about everything probate. If you've got questions about the order for change of venue or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.